Chapter 8. Expedited Processes. Introduction. The Child Support Enforcement Amendments of 1984 require each state to enact and implement expedited processes for establishing and enforcing child support obligations and, at the state's option, to establish paternity. Federal Regulation 45 CFR 303.101a defines expedited processes as administrative or expedited judicial processes, which increase effectiveness and meet processing times specified in paragraph B2 of this section and under which the presiding officer is not a judge of the court. Expedited processes must be in effect by October 1, 1985, or, if legislation is required, at the beginning of the fourth month after the end of the first state legislative session that ends on or after October 1, 1985. After implementation, actions to establish or enforce support obligations in 4D cases must be completed from time of filing to time of disposition within the following time frames: 90% in 3 months, 98% in 6 months, and 100% in 12 months. 45 CFR 303.101b2. These standards were approved by the House of Delegates of the American Bar Association, ABA, and adapted by the Office of Child Support Enforcement, OCS, for use in child support enforcement. The ABA considers the standards to be an appropriate measure of the length of time in which domestic relations cases should be completed from case filing to deposition. This chapter briefly describes 2 expedited process models existing in various states as of the date this handbook is published. As we discuss in chapters 6 and 9, the Child Support Enforcement Amendments of 1984 require each state to establish a mandatory wage withholding procedure and apply it to each case in which an absent parent is delinquent in child support payments in excess of 1 month's support. This mechanism must be applied in both interstate and intrastate cases. As a result of these 2 requirements, states will be enforcing orders which were created in other states by way of establishment procedures that may differ considerably from the procedures in use in the enforcing state. Attorneys who represent absent parents will be unfamiliar and often uncomfortable with the establishment procedures used in other states and may challenge the validity of an order established through one of these variant procedures. Thus, all program attorneys must become familiar with all the use procedures, the arguments attorneys will to attack their validity, and the counterarguments to fend off such attacks. Expedited judicial processes. The concept of an expedited judicial process for child support establishment and enforcement has been in existence since at least 1919, when the Michigan legislature authorized its friend of the court system. See michigan.comp.law Ann. Seconds 552.251 to 552.255. Other states with similar provisions include Delaware, Indiana, Minnesota, Nebraska, New York, Pennsylvania, Rhode Island, Texas, Utah, and Wisconsin. 2 of these states, Delaware, Michigan, Pennsylvania, Rhode Island, and Wisconsin, have implemented the process as their main or exclusive establishment and enforcement mechanism. For this discussion, we define expedited judicial process as a legal process in effect under a state judicial system that reduces the processing time of support order establishment and enforcement effort pursued through full judicial process. To expedite case processing, our model concept assumes judge surrogates with minimum authority to take testimony and establish a record, evaluate and make initial decisions, enter default orders if the absent parent does not respond to notice or other state process in a timely manner, accept voluntary acknowledgement of support liability and approve stipulated agreements to pay support, and if the state establishes paternity using quasi-judicial process, authority to accept voluntary acknowledgement of paternity. Judge surrogates often are referred to as court masters, referees, hearing officers, commissioners, or presiding officers with the above described authority. Pennsylvania procedures. State statutes that authorize the appointment of judge surrogates can be so general as to provide only the authority without much direction, or may be so specific as to set out the procedure in great detail. When the statute is general, the judiciary normally will fill in the details with court rules. The Pennsylvania statute and court rules describe a typical expedited judicial process. See Par. Rules of Civil Procedure, Sections 1910.10 to 1910.13. The rules provide two alternatives from which each judicial circuit may choose. The first option provides for a mandatory office conference in each child support establishment or enforcement case, presided over by a conference officer, who need not be an attorney. If the case cannot be settled at the office conference, the matter is referred to the court for hearing. The second option also employs the office conference, but hearings in disputed cases are presided over by a master in lieu of the court. The court may review the master's decision. The office conference provided for by Rule 1910.11 is somewhat unique. It gives the Pennsylvania procedure the look, and some of the advantages of, the administrative process, discussed below. There are two advantages to requiring such a conference. First, in a large percentage of cases, the parties will agree on an amount of support, and a final order will be prepared to be entered by the court without a judicial hearing. Second, the process of preparing for and conducting the office conference will allow the conference officer to conduct informal discovery into the facts of the case. Should the matter go before the judge, the court file should contain complete information for the judge and the attorneys to refer to during the court hearing. The court hearing no longer functions as an intake interview, except with respect to hotly contested issues. To strike a balance between fairness and efficiency, the Pennsylvania rules reflect several policy decisions with respect to the scope of the conference and the authority and function of the conference officer. The procedure makes maximum use of the conference, including recommendations by the conference officer as to the entry of an order and the amount. The court may act on the recommendation, subject to review de novo upon written request, or the court may defer action, in which case a hearing automatically follows. Important innovative features of Pennsylvania's conference procedure are as follows. The order attached to the complaint directs the parties to bring to the conference certain documents, including their most recent federal income tax return, their pay stubs for the preceding 6 months, and a completed income and expense statement. This information establishes a meaningful basis for the conference. The conference officer may make an informal recommendation to the parties as to the amount of support that should be ordered. If an agreement is reached, the officer will prepare a written order conforming to the agreement. The signatures of the parties appear on the proposed order to signify their agreement. The court, in its discretion, then may enter the order as the final order of support without further hearing. Even if the parties agree on an amount of support, the officer is still empowered to recommend that the court disapprove the agreement. This authority encourages the conference officer to fulfill the traditional judicial function as protector of the best interests of the child, (REN), and prevents a destitute spouse from agreeing to the entry of an unreasonably low order in exchange for some other item or right. Where the parties do not reach an agreement for a support order, the officer prepares a conference summary and recommendation to be furnished to the court and, upon request, to the parties. It contains the facts upon which the parties agree, their contentions with respect to disputed issues, and the recommendation as to the amount and effective date of a support order. The file and summary then are transmitted to the court. The judge reviews the file and conference summary to determine whether a support order should be entered and, if so, whether the recommendation of the conference officer is appropriate. After careful consideration, the court may decline to enter an order based upon the recommendation, or enter an order which varies from the recommendation. If the court declines to enter an order, then a hearing will be held before the court without further action by the parties. If the court enters an order based on the file and conference summary without hearing the parties, the rule requires that the order notify the parties of their right to demand a hearing de novo before the court, and the procedure that must be followed in order to demand a hearing. The order, however, remains in effect as a temporary order pending the hearing, unless the court grants a stay. If an order is entered and no party files a demand for hearing, then the order becomes a final order. In judicial districts that have opted for the alternative hearing procedure, there is again an office conference, but the conference officer does not file a report and recommendations. If the office conference fails to produce an agreement, the matter is referred to the permanent hearing officer, who must be an attorney. The parties are notified of the date, time, and place of the hearing. Prior to the hearing, the parties may request discovery in order to gather additional information not disclosed at the office conference. The permanent hearing officer acts as a judge surrogate to receive evidence, rule on objections, hear arguments, and file with the court a report containing a recommendation as to the terms of a support order. Rule 1910.12b requires a stenographic record of the trial to preserve the testimony for possible subsequent judicial review. The hearing proceeds in a manner substantially similar to a regular court hearing, sometimes even using a courtroom as a setting. Both sides typically are represented by counsel. The permanent hearing officer is an impartial participant at the hearing with the additional charge of protecting the best interests of the child. The normal rules of evidence apply. After the hearing officer prepares a report and recommendations. The report may be in narrative form, but must set forth the specific terms of the order, such as the amount of support, by and for whom it is to be paid, and its effective date. A copy of the report is furnished to all parties. Within 10 days of the hearing, any party may file exceptions to the report, to the permanent hearing officer's rulings on the admissibility of evidence, to statements or findings of facts, to conclusions of law, or to any other matters occurring during the hearing. If no exceptions are filed within the 10-day period, the court must review the report and, with the judge's approval, enter a final order. If exceptions are filed, the court reviews the record placed before the hearing officer, as prepared and submitted by the parties. There is no de novo hearing before the court. Like the appellate court in a regular judicial process, the court hears oral argument and enters a final order. The court generally will refrain from substituting its opinion for that of the hearing officer regarding issues of fact, especially where the credibility or oral testimony may have affected the hearing officer's decision. If the court finds insufficient evidence in the record to support the hearing officer's decision, the court may remand the case for further proceedings before the hearing officer. The court normally will deviate from the recommendation of the hearing officer only where it finds that the hearing officer's report and recommendations contain a mistake of law. Rule 1910.12 provides that the order entered by the court after hearing argument and reviewing the record is final, and that the court may not accept a motion for post-trial relief. If a party disagrees with both the hearing officer's report and the final order entered by the court, he or she must seek relief in the appellate courts. Variations in other states. As noted above, in addition to Pennsylvania, the states of Delaware, Michigan, Rhode Island, and Wisconsin use expedited judicial systems extensively in the establishment and enforcement of child support obligations. The systems in these states resemble the Pennsylvania procedure. Only Pennsylvania, however, has formalized the office conference procedure such that it can result in an enforceable order in default situations. While the authority of the judge surrogates varies from state to state, they generally have the authority to 1. Hold hearings and compel witnesses, 2. Enter orders or recommend orders to the court, and 3. Make findings of fact in divorce, annulment, and separation cases, child support and maintenance cases, paternity cases, child abandonment and neglect cases, and juvenile justice cases. 3.7 Some of the states also have authorized judge surrogates to conduct hearings and make findings and recommendations in interstate cases, a requirement under the Child Support Enforcement Amendments of 1984. One advantage of an expedited judicial process that extends to areas other than child support and paternity is its ability to resolve collateral issues, such as visitation, while a child support or paternity proceeding is pending. This may not maximize the system's responsiveness to the child support caseload, but it does provide a procedural avenue to absent parents who might otherwise feel the system is one-sided. Several states have combined their expedited judicial process with local court administration of many 4D responsibilities. In Michigan, for example, the friend of the court system has been in effect since 1919 to supervise child custody, visitation, and support cases. The Office of the Friend of the Court also receives, disperses, and monitors payments, and investigates and prosecutes absent parents who fail to comply with their support obligations. The Friend of the Court, hired and supervised by the court, also supervises the preparation of reports to the court regarding custody and visitation issues. The court also has the authority to appoint referees to act as judge surrogates in proceedings initiated by the friend of the court or referred by the court. Administrative process. All state legislatures have the authority to set up executive agencies or boards to resolve disputes and claims. These agencies or boards are governed by administrative law, the branch of public law that deals with the limits placed on the powers and actions of administrative agencies. In addition, all states have the capacity to devise and implement procedures for operating these agencies or boards. These procedures, which vary from state to state and from agency to agency, constitute administrative processes. The use of administrative processes for establishing and enforcing child support obligations is a relatively recent occurrence. However, the general concept is as old as the Republic itself. The first Congress of the United States, meeting in 1789, enacted legislation authorizing administrative officers to regulate imports and determine import duties, and to adjudicate claims to military pensions for invalids who were wounded and disabled during the Revolutionary War. By the nation's 1976 bicentennial, the federal administrative process had achieved considerable status, embracing more than 60 independent regulatory agencies and several hundred administrative agencies in the executive department. The administrative process also has been applied within state governments. The workers' compensation and state tax enforcement programs illustrate state-level applications of this concept. Significant parallels can be drawn between these two historic examples and the use of administrative processes to resolve child support disputes. Injured workers were plagued by increasing compensation claims, long court delays, and disparate awards for similar injuries. Child support obligees suffer from similar problems. While child support caseloads have exploded due to increased reliance on welfare by families who are not being supported, child support cases have become bogged down in the courts. Moreover, child support determinations made by the courts show little uniformity. Yet, objective criteria for child support obligations seem amenable to a systematic approach which, in turn, would result in more uniform and, thus, fairer child support determinations. The enforcement of child support obligations also has taken on increased importance to states as welfare expenditures support children when parents should but do not. States have begun to realize that enforcing child support obligations has the same importance as enforcing tax obligations. The administrative child support process can relieve the courts of this overwhelming caseload and place it in a specialized executive agency, where, because of the agency's limited scope, obligations can be determined systematically and uniformly and enforced efficiently when they are not met. 16 states have enacted legislation allowing administrative establishment or enforcement of child support orders. Most of these states use the process almost exclusively in the appropriate cases. Definition. For the purposes of this discussion, administrative process is defined as a statutory system granting authority to an administrative agency to determine paternity and to establish and enforce child support orders. This definition is understood best by analyzing each phrase. A statutory system. State legislatures must enact statutes authorizing the administrative process. State constitutions prohibit agencies from assuming legislative or judicial authority without specific statutory delegations. Before an agency is authorized to determine support obligations by establishing rules of general applicability and by applying those rules to specific cases, a statute must be in place, granting authority to an administrative agency. The statute must authorize the agency to make determinations in contested cases and must provide some manner of enforcing these determinations. In addition, when a state legislature gives a state agency the authority to act in a judicial capacity, there are usually some substantive and procedural matters too detailed for the legislature to address specifically in the law, so that the agency may address these matters. The legislature also gives the agency rule-making authority. Rules promulgated by an agency under that authority carry the weight of law. Thus, in an administrative process, a state agency acts in both judicial and legislative capacities. The administrative or executive agency is usually a subdivision of a state's executive branch, such as the Human Services Department, the Revenue and Taxation Department, or any other agency reporting to the governor. However, the agency may report to another executive official such as the Attorney General or the State Treasurer, or to a commission created and supervised by the legislature. Most child support enforcement agencies are within the state social or human services agency. In this publication, administrative agency, executive agency, and state agency all refer to the state agency that administers the child support enforcement program. Determination of paternity. The executive agency may be granted the authority to determine paternity in addition to setting child support obligations. Clearly, a formal, judicial-type hearing is necessary to establish paternity when the alleged father contests the issue. The agency also may be authorized to establish paternity without holding a hearing in uncontested cases, in cases where the alleged father has acknowledged paternity in writing, and in cases where the alleged father and the mother have married after the birth of the child. Establishment and enforcement of orders. Through administrative adjudication, the executive agency can enter an order similar to a court order requiring the parent to pay a specific amount of child support per month and to repay the state for public assistance paid to his or her family in the past. Once the order is entered, if the parent fails to pay, the executive agency may be entitled to withhold the parent's wages, or to seize other property and credits to collect the money due. Constitutionality. Placing traditionally judicial functions in an executive agency raises some questions, and the question most often heard is, are administrative determinations of child support obligations constitutional? Those who ask this question generally are expressing two major areas of concern. May the legislature delegate this traditionally judicial area to the executive branch of government? May child support obligations be established and enforced by an executive agency without violating a responsible parent's right to due process of law? The first question is one of state constitutional law. The answer depends on the authority the state's constitution gives to the state legislature. Generally, state legislatures have broad authority to determine the rights and responsibilities of its citizens and to establish processes for enforcing those rights and responsibilities. Certainly, if a state has a workers' compensation statute, there is precedent for placing previously judicial functions in an executive agency. Many state supreme courts have had the opportunity to consider whether delegating the authority to resolve workers' compensation claims to an administrative agency violates the state constitution. Such delegations have not been held to violate state constitutional restrictions. The second question raises a more fundamental federal and state constitutional problem. The 14th Amendment to the U.S. Constitution provides that a person shall not be deprived of life, liberty, or property without due process of law. The U.S. Supreme Court has established some very important criteria for due process. These fall into three general areas: right to notice, right to a hearing, right to judicial review of administrative action. A person has a right to be notified of any action being taken that concerns his or her liberty or property. All child support administrative processes require the executive agency to notify the responsible parent of the amount being claimed and the procedure for contesting the claim. These statutes further require that the executive agency serve the notice in a manner reasonably calculated to give the responsible parent actual notice. The courts also have specified the type and quality of hearing necessary before a person is deprived of property. The hearing must be fair and impartial, and the person entitled to the hearing must have reasonable opportunity to present evidence through documents or witnesses, confront the opposing party, and refute any evidence. Administrative processes, as presently being used, allow the alleged responsible parent to present all evidence in his or her favor with the aid of an attorney if desired. The administrative decision must be in writing and must be based solely on evidence submitted at the hearing. 6. A proper hearing includes the right to appeal to a judicial authority. In all administrative child support processes, the responsible parent may request that a higher authority review the facts on which an order is based or the law which was applied. In all the processes, questions of law may be appealed to the judiciary. Establishing obligations. The administrative process may be used to establish the initial support obligation in cases that do not already include court-ordered support, and it may be used to determine the amount of arrearages due under an existing judicial order. The procedural steps for obtaining the administrative order under these two situations are similar. The child support agency first must locate the absent parent prior to considering the case for administrative process. Usually the agency will conduct an initial inquiry into the absent parent's financial situation through information available from other state agencies, for example, taxation or employment security, or from formal or statutorily mandated devices such as absent parent financial statements or employer reports. This information may be used to compute the amount of the child support obligation where no order exists, or to locate income or assets for enforcement of an existing administrative or judicial order. Once the absent parent is located, the state child support agency will prepare a notice of the child support obligation, and the typical administrative process will follow the 5 steps described below. Step 1. The Notice of Child Support Obligation. The state agency obtains jurisdiction over the absent parent by serving on him or her a notice of the child support obligation either by personal service, certified mail, return receipt requested. Some states allow service by first-class mail. Under existing state statutes, the notice must contain, at a minimum, the names of the children for whom support is sought, the rights of the absent parent, including the rights to a hearing and representation by an attorney. Notice that a default order can be entered if the absent parent does not respond to the notice. Notice that the absent parent must respond within a reasonable period of time specified by the statute. Notice that the absent parent may appeal an administrative determination to a court of competent jurisdiction. An allegation of debt owed to the state for past assistance provided to the parent's dependents, often referred to as state debt. The amount of current support to be paid, based on a formula required by 45 CFR 302.53, or arrearages that have accrued under an existing order. Instructions on how to obtain a negotiation conference. A listing of the various collection actions that may be instituted once the administrative order is entered. Step 2. The absent parent's response. The absent parent may respond to the notice in one of 4 ways. He or she may fail to take any action within the time specified in the notice, in which case he or she will be in default. The agency then may enter a default administrative order in the amount alleged in the notice. He or she may consent to pay the amount requested in the notice, in which case the agency will enter a consent or stipulated administrative order consistent with the notice. He or she may request a negotiation conference with the agency at which he or she will argue for a support amount different from that requested in the notice. If negotiation is successful, the absent parent and the agency will enter into a consent or stipulated administrative order. If the amount of child support, state debt, or payments to be made on the state debt, or arrearages due cannot be agreed on during negotiation, or if the absent parent refuses to negotiate, he or she may request a hearing by filing a formal request within the time set by statute. If the absent parent does not request a hearing, the agency may enter a default administrative order, based on the obligation alleged in the notice. Step 3. The administrative hearing. When the absent parent makes a timely request for a hearing, the case is scheduled before an administrative hearing officer. Usually, the agency worker or an attorney represents the agency in the administrative hearing, and the absent parent represents himself or herself or is represented by an attorney. The administrative hearing officer is a state employee, usually appointed by the agency director. The state statute may provide that hearing officers be employed by a separate agency, such as the Attorney General's office. The hearing officer represents no one, and conducts and controls the hearing as an impartial examiner of the facts. The administrative hearing usually must be a hearing of record. A file is maintained, all pleadings, memorandums, and physical evidence are labeled, and all testimony is recorded. Most often, the hearing is tape-recorded. The record is preserved for a period prescribed by statute or rule, and is transcribed for review if the absent parent appeals the hearing officer's decision. The rules of evidence in an administrative hearing are less formal than in court. Most states have enacted a version of the revised Model State Administrative Procedure Act, APA. Sometimes the APA is cross-referenced in the Administrative Child Support Statute so that its procedural provisions apply. The APA describes the form, oral testimony, documents, and affidavits, and the admissibility of evidence. Evidence not normally admissible in a court of law, certain types of hearsay, for example, may be admitted by an administrative hearing officer if he or she determines that the evidence is reasonably reliable. The hearing officer may take notice of the same matters of which a court may take judicial notice. In an administrative hearing, as in civil judicial proceedings, the burden of proof or risk of non-persuasion is generally on the party who initiates the action, that is, the state agency. This means that the agency first presents evidence which establishes its case, and then the absent parent attempts to counter this evidence. As specific elements of a case, the state may want to show that the absent parent owes a duty of support, that the absent parent has not complied with an existing court order, the absent parent's ability to provide support, and the state's interest in the proceeding. The absent parent may cross-examine the state's witnesses and present his or her own evidence, which the state may rebut. The hearing officer weighs the evidence and rules in favor of the state or the absent parent, depending on whose evidence is more persuasive. Some state administrative process statutes impose a show cause requirement on the absent parent. This lessens the agency's burden of proof by requiring the absent parent to prove that he or she should not be required to meet the agency's demands, or that he or she does not owe the amount of support arrearages claimed. In this case, if the absent parent does not show cause why the administrative order should not be entered in the amount requested, the hearing officer must rule in favor of the agency. Step 4. The administrative order. The final decision and order recites, in writing, pertinent facts of the case, for example, names, birth dates, employer, and income, and the legal conclusions drawn, for example, duty of support, amount of the obligation, and arrearages. The order also contains important information, such as where, how, and when support payments are to be made, the consequences of non-payment, and notification to the absent parent of his or her right to, and the method and time limits in applying for, review of the agency's decision. The order may be filed with the court, or it may be maintained internally by the agency, depending on the statute. Step 5. Review of the administrative order. Most states' administrative process statutes contain specific provisions describing the nature of review available and how review must be requested. Most states provide for direct judicial review of the administrative order, although some allow for an initial internal agency review by an agency official or review board. Regardless of specific statutory provisions for judicial review, all executive agency decisions that affect an individual's rights or property are subject to judicial scrutiny. Review ensures that statutory procedures have been followed, that constitutional rights have been protected, and that the agency's decision is supported by substantial evidence. If the administrative process statutes of the state do not specify a review process, non-statutory remedies developed by the courts may apply, for example, writs of prohibition, certiorari, or mandamus. In addition, if the administrative process statute or state APA do not specify a procedure for requesting judicial review of the agency's order, the absent parent may apply to the courts for equitable relief against the enforcement of the administrative order and may challenge the validity of the administrative order. State statutes commonly provide for judicial review on the record. If the absent parent requests judicial review, the agency prepares a complete record of the administrative proceedings, including all documents filed and a transcript of all oral testimony. The parties may file briefs and make oral arguments before the court, and the court examines the record and considers legal arguments. The court may affirm the agency's decision, or remand, return the case to the administrative agency for a new hearing or a new order to be entered in compliance with the court's findings. In this type of judicial review, the court generally does not weigh the evidence again and substitute its judgment for that of the hearing officer. The court may reverse or modify the agency decision only if substantial rights of the absent parent have been prejudiced during the administrative hearing, or if the administrative decision violates statutory or constitutional provisions, exceeds the agency's statutory authority, or is not supported by substantial evidence. Alaska and Virginia allow the court the option of either reviewing the agency record or holding a hearing de novo. Some states allow an agency official or agency review board to review the administrative order. Under this type of review, the official or board may exercise a review on the record, much like the judicial review on the record, or the agency may allow an administrative hearing de novo. If there is a provision for internal review of the administrative order, the absent parent generally must exhaust all administrative remedies before seeking judicial review. Administrative enforcement mechanisms. Administrative remedies differ from judicial remedies in that they are imposed by the agency in lieu of the courts. Existing administrative process statutes have established a number of administrative enforcement remedies. Statutes vary concerning the procedures the agency must complete in order to affect the non-complying parent's property. Below are summaries of existing administrative remedies. Administrative garnishment. The most common administrative enforcement remedy, an order to withhold and deliver, is used to seize property, usually money, belonging to an absent parent that is in the possession of a third party, for example, employer, bank, credit union. The order is issued by an agency official and usually served by certified or regular mail on a person or officer of the company in possession of the absent parent's property. Typically, the order will recite identifying information about the absent parent, the amount to be withheld, the amount and types of property exempt from withholding, the procedure for delivering the property to the agency or court clerk, and information describing the withholder's liability for failing to comply with the order to withhold and deliver. The most commonly used order to withhold is for wages. This type of order is continuous and may remain in effect for the entire life of the support order. The most commonly used order to withhold is for wages. This type of order is continuous and may remain in effect for the entire life of the support order. Under the 1984 amendments, mandatory wage withholding will be the preferred enforcement remedy in all child support enforcement agencies. All newly established or modified support orders must include mandatory wage withholding as an automatic condition when an absent parent becomes delinquent in paying child support. Administrative liens. The statute may prescribe a procedure for recording a lien against a non-complying absent parent's real and personal property. The lien usually is accomplished by filing a document with the court clerk or county recorder of deeds in the county in which the property is located, similar to the state's procedure for creating judgment liens. The lien encumbers property so that, if the absent parent attempts to mortgage or sell the property, a title search will reveal the lien. In practice, the absent parent or the purchaser of the property usually will pay off the support arrearage in order to release the lien, so that the property will not be subject to seizure and sale by the agency or the support obligee. Seizure and sale of property. Some existing administrative process statutes provide that once a lien is recorded, the agency may take possession of the absent parent's personal property, for example, automobiles, guns, jewelry, and may advertise his or her real property for sale. The procedure is similar to seizure and sale, or levy and execution, under the state's civil law mechanisms for collecting judgment debts. In administrative seizure and sale, the Child Support Enforcement Agency, rather than the court, authorizes and carries out the seizure of the property and advertises and holds the sale. The sale proceeds, less the costs of seizing the property and holding the sale, are applied to reduce or satisfy the support arrearages. Income tax refund set-off and interception. Support arrearages which accrue under an administrative order may be submitted to the Internal Revenue Service for income tax refund set-off under 42 U.S.C. 664 and Section 6402 of the Internal Revenue Code. In addition, 42 U.S.C. 666(3) requires states to implement a similar set-off procedure for state income tax refunds. This procedure will include an administrative review process for settling contested tax refund interceptions. The same hearing officers who conduct hearings for establishing and enforcing support obligations also often conduct contested tax refund reviews. Enforcing judicial orders administratively. Many administrative process statutes allow the Child Support Agency to enforce prior judicial support orders through some or all of the enforcement means described above. The agency must notify an absent parent prior to using an administrative remedy to enforce a judicial order, but the statute does not always spell out specific hearing procedures. Some statutes require the agency to complete the statutory procedures for establishing an administrative order before using administrative remedies to enforce a judicial order. Other statutes require the agency merely to notify the absent parent of the impending enforcement action. With this latter procedure, the absent parent's sole method of contesting the administrative enforcement is to seek relief in the court which entered the order. Judicial enforcement of administrative orders. Some administrative process statutes allow the agency to file its order with a court in the county in which the children or absent parent reside. Once filed, the order becomes an enforceable order of the court as though it had been rendered by a judge. In these states, which include Utah, Missouri, and Oregon, traditional judicial enforcement mechanisms are available in addition to any administrative enforcement remedies provided for by statute. Modifications. Some administrative process statutes allow the agency to modify administratively entered child support orders. The statute will specify the criteria and the procedures for notice and hearing in an administrative modification proceeding. Generally, once the notice provisions have been met, a modification proceeding follows the same methods for hearing and review as for administrative establishment, with the additional requirement that the party seeking the modification must prove a change of circumstances. Appellate decisions involving administrative process. To date, 7 appellate decisions have been rendered in states that use administrative processes for child support establishment and enforcement. 5 of the decisions are from the state of Washington, 2 from Utah. The first Washington case is Taylor v. Morris, 564 P2D 795, Wash. N. Bank, 1977. The issue here was simple: did the Washington Administrative Process Statute, RCW 74.20a, confer upon the Department of Social Services the authority to determine administratively the question of paternity? The statute did not expressly confer such authority, but the department argued that it was implied necessarily by the statute, which did expressly authorize the department's hearing officer to determine the liability and responsibility, if any, of the alleged responsible parent. The court held that the statute was aimed toward the quantification and enforcement of the support obligations of responsible parents and not determinations of parentage itself. Woolery v. Department of Social and Health Services, 612 P2D1, Wash. App. 1980, followed the Taylor case to prevent the Washington 4-0 agency from determining administratively the paternity of the Woolery children in a 4-0 eligibility hearing. The issue was whether the father of the children was in the home during a period of time when Mrs. Woolery was drawing AFDC. Although the case concerned a different administrative process, the decision strengthened the concept laid out by the Washington Supreme Court in Taylor. Whitehead v. Department of Social and Health Services, 595 P2D 926, Wash. N. Bank, 1979, involved a construction of the appeal mechanisms afforded to responsible parents by the Washington statute, and whether attorney's fees are available to reduce the cost to the responsible parent of an appeal from the decision of an administrative hearing officer. The decision is probably peculiar to the Washington Administrative Process Statute, which authorizes such appeals by reference to another Washington statute. The incorporated statute contains the attorney's fee provision, not the administrative process statute. Nevertheless, the decision held that attorney's fees are available to aid the absent parent in seeking judicial review. The fourth Washington case, Powers v. Department of Social and Health Services, 648 P2D 439, Wash. App. 1982, deals with the effect of an existing custody and support decree on the 4D agency's authority to use its administrative process statute to establish a current obligation and to enter judgment for reimbursement of AFDC paid to the family prior to entry of the administrative order. The facts were not unusual. A divorce decree gave custody to the mother and ordered the father to pay $150 per month, $50 per month per child. Subsequently, the decree was modified to transfer custody to the father. Several years later, the mother picked up the children without the father's consent and later began drawing AFDC. The Washington 4D agency treated the case as though no support order existed, and served the father with a notice and finding of financial responsibility. The administrative hearing officer ordered the father to pay $315 per month current support and to repay accrued estate debt, unreimbursed prior AFDC. of $4,899.80 in installments of $70 per month. The decision has positive and negative implications. On the positive side, the court did not allow the father's legal custody to insulate him from the 4D agency's claim. On the other hand, the court limited the claim to $150 per month, despite the fact that the support provision of the divorce decree had been modified out of existence. The fifth Washington case is Durance v. Wallace, 743 F2D 709, 10 Floor 1684, CA 9 1984. Here, the Ninth Circuit Court held that the administrative garnishment procedure authorized by Washington's Administrative Process Statute does not violate the absent parent's right to due process. The decision analyzes the due process factors contained in the U.S. Supreme Court's decision in Matthews v. Eldridge, 424 U.S. 319, 1976. To determine the notice and hearing rights of an absent parent in an administrative enforcement proceeding. The Washington statute allows for administrative enforcement of existing judicial orders by way of a summary procedure. The Washington 4D agency may initiate enforcement of a judicial order simply by notifying the obligor of the amount due under the order and that his property is subject to collection action. RCW, Sec. 74.204.040, after the expiration of a 20-day waiting period, the agency may serve the administrative garnishment, called an order to withhold and deliver, on the obligor's employer, who is directed to turn the obligor's wages or property over to the agency after another 20 days expires. R.C.W.Sec. 74.204.080. The absent parent argued that the agency violated due process in failing to grant him a prompt post-garnishment hearing and to inform him fully as to all available exemptions which would insulate his property from the garnishment. The court rejected both arguments, stating, because of the strong governmental interest in the support of children and the expeditious enforcement of judgments, the relatively small risk of erroneous deprivation, and the negligible value of alternative procedures, we find that the present procedures do not violate due process. The court held that informal communications between the agency and the obligor were sufficient, that is, no formal administrative hearing, prompt or otherwise, is required, given the obligor's alternative to seek immediate judicial relief in the court that entered the support order. The court further held that the notice, which stated in summary the wage exemptions available to the obligor and which advised the obligor to seek judicial relief on the basis that no support debt is due and owing, were sufficient to notify him or her of available defenses and the procedure for asserting them. The two Utah cases are likewise instructive. Pilcher v. Department of Social Services, 663 P2D 450, Utah 1983, treated several important issues. First, the Utah Supreme Court noted that the purpose of the administrative remedy is not furthered by application of the technical rules of pleading and procedure used by the courts. The opinion ratified the use of an amended notice and finding after service of the initial notice on the absent parent to change the amount of support prayed for, even though the statute provided for no such amended pleading. Next, the decision concluded that the 4D agency was well within its authority in basing the support amounts contained in the notice and finding on a Texas court order. This has the effect of allowing administrative registration of an out-of-state court order, which gives the agency a bit more flexibility in using the administrative process. The most important facet of the opinion holds that the procedure may be implemented retroactively to create administrative orders for amounts owed prior to the effective date of the statute. The court noted that the Administrative Process Statute was remedial, simply providing a new procedure to enforce a pre-existing obligation. That being the case, retroactive application offends no constitutional principle. The facts in Pilcher involved converting court ordered arrearages into an administrative order. The logic of the decision as to retroactivity also should apply to the creation of a state debt, based on the amount of AFDC benefits provided to the family, for a prior period during which no court order was in effect, at least in states where a common law reimbursement of necessaries action exists. The other Utah case is Knudsen v. Utah Department of Social Services, 660 P2D 258, Utah 1983. The decision holds that the entry of a divorce decree which makes no mention of the father's obligation during the pendency of the divorce case does not prevent the 4D agency from employing its administrative procedure to seek reimbursement of AFDC provided to the family during that period. The Utah Supreme Court held that since the issue of Mr. Knudson's obligation during the period was not actually litigated in the divorce, the doctrine of res judicata did not apply. As to the obligation to be determined in the administrative process action, no court order existed. The decision contains a troublesome conclusion as well. The court concluded that the responsible parent must be given credit, against the state debt claim, for contributions he made to the family by way of mobile home mortgage payments, despite the fact that he retained a 1/2 interest in the mobile home and was accruing equity as a result of the payments. This conclusion reduces the remedy's emphasis on the state's claim for reimbursement. The statute creates a debt in the amount of AFDC provided, which then is adjusted by taking into account the responsible parent's ability to pay during the period for which reimbursement is sought. Such an adjustment complicates matters greatly. The Knudson case goes one step further by requiring the agency to give the responsible parent credit for so-called in-kind contributions that were made to the family, despite the fact that the responsible parent had been notified that his support obligations must be channeled through the state. A new role for the courts. Throughout the history of the Child Support Enforcement Program, the judiciary has been the focus of case processing activity. Judges have entered orders, established paternity, and provided the authority for all enforcement activity. The judiciary has been an important guiding force on the front lines of the child support enforcement effort. In mandating all states to implement expedited processes and summary wage withholding procedures, Congress has forced a change in the role judges are to play in the process. Of course, many things will remain the same. Judges will still enter support orders in divorce proceedings, and these orders will continue to be a significant percentage of the obligations enforced by program personnel. In most states, judges will continue to preside over contested paternity proceedings. Other states, no doubt, will opt to delegate the conduct of these hearings to the presiding officers in their expedited processes. Furthermore, judges will continue to sit in difficult enforcement proceedings. Contempt will continue to be an important remedy against absent parents who do not have readily identifiable income or assets. Routine establishment and enforcement should require significantly less judicial involvement. In states that enact administrative processes, trial judges generally will act in the traditional role of the appellate court. In this role, judges will oversee, on an infrequent basis, the implementation of the administrative process. Judicial involvement in states that opt for expedited judicial processes will be more extensive. In most jurisdictions, judges will become involved in individual cases only rarely, upon request for review. Nevertheless, the judiciary's role as manager and overseer of the process will be crucial to the success of the new procedures. Judges often will be authorized to hire and supervise the presiding officers and other court personnel who drive the system. As such, judges must be aware of the administrative problems and needs of the program within their judicial circuit or district. The success of the process demands nothing less than a significant commitment of effort and resources, and a commitment to successful implementation.